Deputy Commissioner of Police Abba Kyari, who was once known as a super cop, must be having sleepless nights right now. Despite his feeble attempts at denial, the Attorney General of the Federation and Minister of Justice Abubakar Malami has confirmed that a prima facie case has been established against Kyari, linking him to Nigerian internet fraudster Ramon Abbas, better known as Hushpuppi. Abbas is standing trial in the United States for being the mastermind behind a multi-million-dollar internet scam and money laundering syndicate. Shortly after his arraignment, a U.S. judge, Otis Wright, ordered the arrest of Abba Kyari for collecting money from Hushpuppi to detain a fellow fraudster in Nigeria. Malami has now compounded Kyari's problems by stating that the chances of his extradition to the United States to stand trial are high. Joining us now to discuss the Hushpuppi-Kyari saga and interrogate why the Nigerian government is not considering the option of prosecuting the police officer rather than extraditing him to the United States is Kunle Adegoke, a senior advocate of Nigeria. Good morning, Mr. Adegoke, and thank you for joining us on the morning show. Okay, good morning, welcome. Well, quickly, we just want to get your perspective on what the Attorney General of the Federation said about the fact that a prima facie case has now been established against Abba Kyari, the policeman who was linked with Ramon Abbas, Hushpuppi, based on investigations by the Federal Bureau of Investigation in the United States. What is the process of extradition? And what is the Attorney General relying on, in your view, beyond the statement that, various jurisdictions had worked on this? Because you recall that a panel that was set up by the Police Service Commission did not indict Abba Kyari. Can you hear me?
Thank you very much. Yeah. Yes, I can hear you very well. Thank you very much, Dr. Abati.
You're welcome.
Principal law regulating extradition in Nigeria, aside from the Constitution of the Federal Republic of Nigeria 1999, is the Extradition Act of 1967. There are some other laws relevant to extradition as well. However, first consult must be made to the Extradition Act, which is the principal act. The Attorney General has the prerogative to determine whether an application should be made to the court for an order extraditing a fugitive offender. The provisions of the Extradition Act makes this the right of the Attorney General to exercise where there is a request from a country with which Nigeria has an extradition agreement. If the United States has made a request for the extradition of Abba Kyari, the procedure is such a request will be made to the Attorney General of the Federation through the consular or the diplomatic agencies. And with that, the Attorney General will look into the request vis-a-vis the evidence provided by the requesting country to see if an offense has been committed. 2, if the offense is actually an extraditable offense. There are some other factors that the Attorney General will look into to take a decision whether he should make such an application to the Federal High Court for an order extraditing the fugitive offender. One of such in determining whether the offense is extraditable is to consider if the offense for which a request is being made is not a political offense. If the offense is a political offense, for instance, something like treason, sedition, disagreeing with government ideology, or such like, will not be extraditable offenses. And on that basis, they are treated as political offenses. On that basis, once the Attorney General has made up his mind that, yes, the requesting country has met the requirements for making such a request, then he will bring an application to the Federal High Court asking for an order to extradite the particular offender. The process in court, the proceeding, is not to determine the guilt or otherwise of the fugitive suspect or offender. The procedure at the level of the High Court is to determine whether the requirements have been met in accordance with the discretion exercised by the Attorney General. Where the request made by the Attorney General is in respect of an offense that is not extraditable, the court will not grant it. But once the court too has seen that the prerogative of the Attorney General has been fairly exercised, then on that basis the court will make such an order. And that is just the summary of the procedure.
Thank you, sir, for that overview. Should the Attorney General decide to exercise his option not to pursue these courses that you've outlined just now, what would that implication be for Nigeria and our relations with the United States of America? Not saying, of course, that he will do that, but should he refuse to pursue this extradition or somehow frustrate the extradition that's been requested, what will happen with regards to Nigeria and our relationship with the United States?
Well, if the Attorney General, who has the sole prerogative to determine whether such a procedure should be followed or otherwise, decides not to take the step and thereby refusing to make the necessary application to the Federal High Court for a relevant order, there is virtually nothing the United States can do except to strain relations with Nigeria. Our relationship with the United States may become strained internationally. However, I do not suspect that, well, a certain animosity may develop between the two countries. I do not see it as probably leading to war or something. The implication is that where Nigeria has maybe a desire to gain some advantage from the United States, such advantage may be refused by the government of the United States. However, where the Attorney General of the Federation decides to make the application to have the suspect extradited, it is still not final with him. It is still upon a decision by the court. Because in international law, what actually brought about the idea of a cooperation between nations to decide whether a suspect should be extradited or otherwise is on the principle of equality, by which no nation can superimpose its desires over another. We say the maxim is par imparem non habet imperium. That is, an equal does not command an equal. So the United States cannot come into Nigeria. Yes, it has been done in the past, in the case of Noriega and some others like that. But in international, the rules of engagement in international law will ordinarily not allow the United States to step into the territory of Nigeria to pick Abba Kyari. Another fundamental fact that we must look at, because the fact that Abba Kyari did a particular act or took a particular step in the course of his relations with Abbas Hushpuppi may not necessarily make it conclusive that the request of the United States must be granted. There is one fundamental thing that most people, most commentators have not really been looking at. Can we properly, in international law parlance, describe Abba Kyari as a fugitive suspect, strictly speaking? Because when a nation is making a request for an offender to be extradited for that nation to try such an offender, the suspect must be a fugitive. And by the definition of a fugitive offender under the Extradition Act in Nigeria, must be somebody who committed the offense in the requesting state, in the country that is asking for the extradition of the offender, and has now run into Nigeria, is now resident in Nigeria. But where the offense is one that was not committed in the requesting state, probably may have connections with maybe some other states, Nigeria may lawfully refuse to extradite, to grant the extradition request of the United States. The proper thing, however, for the Attorney General of the Federation to do is that once it is established that the offense committed by the suspect is one known to the Nigerian law by whatever provision, whether the EFCC Act or Money Laundering Act or whatever, then Nigeria ought to prosecute that particular offender. Otherwise, we will be seen in international law, we will be seen before the Committee of Nations as a country that protects fraudsters, that protects unlawfully protect offenders, and that will not speak well of the image of Nigeria. I would rather advocate a situation where the Attorney General of the Federation will take the necessary steps in prosecuting Abba Kyari once it is established that he has committed the particular offense or offenses for which the United States is making a request for his extradition. It will be highly improper and would denigrate the status of Nigeria before the international community to refuse to prosecute and refuse to extradite the offender. But it is fundamental for us to realize that the purpose of extradition is not to transfer the jurisdiction of Nigeria to a foreign country. It is not an opportunity to abdicate from our own prosecutorial responsibility, now awarding same to the United States to prosecute an offender for an offense that is also a crime in Nigeria. Yes, once the conditions are met, then the particular offender ought to be allowed to be extradited. But in the instance, in the present case that we are talking about, I do not think that Abba Kyari can be described as a fugitive offender in respect of whom the extradition request of the United States ought to be granted. However, the Attorney General of the Federation has been slacking in his responsibility with respect to taking appropriate criminal steps against Abba Kyari. Because if a trial is going on in Nigeria against Abba Kyari and the same offense, for the same offense that the United States is asking for extradition, then it may not be granted by the Attorney General and the court may equally refuse it because it will amount to double jeopardy if he were to be facing trial here and at the same time be facing trial in the United States. That is not allowed in law.
Okay, thank you very much, Mr. Adegoke, for explaining to us the equal footing principle in law and also the fact that that is important. Even if there is that other principle, pacta sunt servanda, agreements must be kept. However, I wanted to ask you.
Once it is pactum, it must be servandum.
Yeah, but I want to ask you, do you think that the Attorney General, in going forward to say, oh, a prima facie case has been established, do you think he jumped the gun? Because you recall that a four-man panel led by a Deputy Inspector General of Police was set up. That panel did not indict Abba Kyari. The report was submitted, the papers reported, to the Office of the Attorney General. And then 2 weeks ago, the Attorney General then advised that that investigation that was done by that four-man panel instituted by the IG and the Police Service Commission did not do thorough enough investigation. Now, nobody knows whether that panel has conducted another investigation and has reported back to the Attorney General. And yet, you have the Attorney General out there saying that, look, a good case has been established against this person. Do you think that he spoke too early, too soon, regardless of the advice that he himself had given the police?
Thank you very much. The particular thing that we must pay attention to here is that, first, there are so many grounds to disagree with the Attorney General on so many issues, more essentially with his acts in the past. But with respect to the present case concerning Abba Kyari, the Attorney General of the Federation might not have gone too far away from his powers, from his rights to make up his decision on whether a prima facie case has been made against Abba Kyari or otherwise. In fact, the constitution of a panel to investigate the officer in question is not part of the procedure for determining whether the offender should be extradited or not. It's not part of the procedure for determining whether a prima facie case has been made or otherwise. There is no requirement in law that there must be a prior committee that will investigate the particular officer where a request has truly been made. If a request has been made by the United States to Nigeria, the provision of the Extradition Act vests the power in the Attorney General to decide if, in his opinion, he considers, having looked at the criteria for determining whether there is an offense, whether the offense is extraditable. Once he has made up his mind on that, his decision is to a large extent final, and the only body, the only panel that can look into the correctness or otherwise of his decision is the courts. Formerly, it used to be the magistrate court, but by the 1979 and 1999 constitutions, making extradition an exclusive legislative item in the Constitution, then the power has been transferred to the Federal High Court to decide. So it is only the Federal High Court in this instance that can now look into the decision of the Attorney General, refuse same or grant it. I have been involved in a case, which in any case to a large extent has become a locus classicus on the issue whether Nigeria has an extradition agreement with the United States or otherwise. And that particular case, the decision in that case by the Federal High Court before the Honorable Justice Buba became the reference by which the United Nations UNODC published a whole 691-page book. And it spurred the organization to look into the requirements for extradition. It is common position that it is the Attorney General of the Federation that has the power to determine whether there is a prima facie case in respect of a fugitive suspect or otherwise. Once he has made up his mind, it is not for a committee to either take a prior action or a post-decision action as to determine whether the Attorney General of the Federation is right or not. If today the Attorney General has said that a prima facie case has been made, the next question is, what is he doing about it? If he has made up his mind, then he ought to have taken the necessary step of applying to the Federal High Court to carry out the extradition process. If he fails to do that, then it means that it is not being honest enough in the performance of his responsibilities. But on this particular issue, I believe the Attorney General of the Federation is very, very correct on his assessment may be wrong, but in exercising his discretion, he has taken a right step. The discretion may be decided against by the court. If you look at the case that I referred to, the Federal Republic of Nigeria and Rafiu Kofoworola, aka Big Brother Olayinka, he has so many names. I defended the suspect in that particular case. The United States requested for Rafiu Kofoworola to be extradited in relation to drug peddling and charges and what have you. Now the request was made to the Attorney General of the Federation. Then I think Mohammed Adegoke, who decided that Kofoworola should be extradited, and he immediately made a request to the Federal High Court. The matter was argued before the Honorable Justice Buba, and it was our contention, actually, that there was no extradition agreement between Nigeria and the United States. The court ruled against us. To a large extent, that is a decision of the court, which is quite binding on all authorities, including our own small cells. So to that extent, I believe that the Attorney General's decision that a prima facie case has been made cannot be detracted from by the decision or recommendations made by a committee set up by the Inspector General of Police. In fact, in the corpus of our law, the Inspector General of Police has no role to play in determining whether a prima facie case has been made or otherwise, because it is for the Attorney General to decide. The Attorney General is correct on this.
Right, thank you, sir. Thank you. Earlier on in the show, we're talking about dropped balls and people who just were not alive to their responsibilities in the context of the current fuel scarcity. So in this context, what exactly happened here? We have that Article 4 of our extradition treaty with America saying that extradition will not be possible if the suspect has already been tried in their home country, i.e. Nigeria in this case, so no double jeopardy, or if a trial is ongoing. Why is it that the Nigerian authorities failed to flag the activities or alleged activities of Abba Kyari, and it took the FBI, and it took a case that has now been marked to USA and Abba Kyari, dated April of last year? Who dropped the ball here? What kind of loopholes should we be looking at in the way that we actually enforce discipline within the police force? Should the Police Service Commission be held to account for this to some extent?
Right. I believe that the Police Service Commission, both the Office of the Attorney General of the Federation and the Police Service Commission or the relevant authorities, the Office of the IG, can be held to have been derelict in the performance of their responsibilities in this regard. And the reason is, if certain allegations are made against a particular officer of Nigeria, and it has taken so much of an international dimension, and a fellow, a person has been accused, has been charged for the same offense or offenses in the United States, already about to be convicted, I think it is not too good for the Office of the Attorney General of the Federation or the Office of the Inspector General of Police or the Police Service Commission to have refused to take an appropriate step in this respect. The matter has taken so many months now, if not running to more than a year, since Abbas Hushpuppi was arrested, was extradited to the United States. And insofar as this is a crime that is, celebrated everywhere, is a case that is celebrated everywhere and getting reportage on a daily basis, I think it is quite shameful that Nigeria has not lived up to its responsibilities in criminal prosecution with respect to Abba Kyari. If we say all citizens are equal and nobody is above the law, it is quite very, very unfortunate that Nigeria has not lived up to its responsibility in this regard. Abba Kyari, for whatever anybody may say, yes, performed as a super cop and what have you, but in the course of excellent performance, if there are infractions that are so egregious in nature that the whole world is screaming blue murder, that how do you expect an officer of Abba Kyari's standing that has garnered so much recommendations from everybody to have been involved? That means that it is possible he could have been committing all these kind of crimes unnoticed. It is very, very fundamental that Nigeria ought to have looked in that direction. And Abba Kyari by now should have been undergoing prosecution, should have been undergoing trial in Nigeria. But unfortunately, neither the Attorney General of the Federation nor the Inspector General of Police, who also has the power not only to arrest, but equally to institute criminal proceedings, have both been found wanting. And we haven't heard so much from the Police Service Commission making appropriate recommendations. Yes, Police Service Commission will not prosecute by itself. It will take either the Inspector General of Police or the Attorney General of the Federation to institute proceedings in this respect. But it is quite sad that none of these organizations, none of these offices, none of the individuals occupying these lofty positions has taken any step appropriately in criminal prosecution against Abba Kyari. The implication is that we are covering up the act, we are covering up the crime alleged to have been. It doesn't mean that Abba Kyari is guilty immediately before prosecution. However, Nigeria ought to have taken steps. If Nigeria had commenced prosecution against Abba Kyari, because the offense he committed, yes, they said he assisted in wire fraud and then arrested one Chibuzo, a conspirator with Abbas Hushpuppi, detained him to allow a criminal process of illegal extortion also to be perpetrated undetected. Yes, these are grievous crimes that Nigeria by now, I think even prosecution by now would probably have been concluded maybe Abba Kyari would either have been convicted or acquitted, as the case may be. Nobody can immediately predict until it gets to the court of law. But failure to prosecute Abba Kyari has shown that Nigerian government is not serious about the anti-corruption fight that we have made a lot of noise about. And the expectation from our government, of which I am one of the major supporters, is that Nigeria is not, the expectation is that Nigeria ought to have been more serious in its anti-corruption fight. Nobody can excuse this kind of acts that are alleged against Abba Kyari. Once Nigeria has commenced prosecution, I am quite sure that whatever extradition request that the United States has been planning to make or that has made will definitely be dropped, no matter what is going to be the consequence of the prosecution in Nigeria, because no single alleged offender will be subjected to trial in two jurisdictions for the same offense.
Amount to double jeopardy. But in August 2021, the editor of This Day Lawyer, the law section of This Day newspaper, Onikepo Braithwaite, wrote a piece on this same subject. I think it was August 10, where she said that, look, this is not just about Abba Kyari being on trial. That is the entire police institution in Nigeria that is on trial. You've talked about government, how government will look very bad. But how does this reflect badly on the police as an institution? The same police force that many Nigerians are very disturbed about. In fact, in 2020, young Nigerians went to the streets to say that we have a rogue police force in Nigeria. What are your thoughts on that? And how do you think we can prevent, super cops becoming rogue cops?
Yes, in fact, the image of the Nigerian police today is one that is not commendable at all. It's one that is quite disheartening to perceive on a daily basis. And we wake up in the nation, we wake up to the international community being regarded as people of no consequences. What do I mean by people of no consequences? That acts, egregious criminal acts are perpetrated in Nigeria without consequences. Offenders get away smoothly. And why is this so? It is because the police that ought to effectively police and prevent crimes and prosecute crimes, that particular institution has been completely derelict in the performance of its responsibilities. We have cases, we have millions of cases currently pending in various courts, from the magistrate courts to the High Court to the Court of Appeal, even up to the Supreme Court, indicting the Nigerian police of so many crimes that you even wonder whether we need criminals anymore once we have the Nigerian police. Because there is virtually no difference between those who wear our uniforms and those who perpetrate crimes either on the highway or invade homes to rob, rape, or commit all sorts of crimes. The implication is that the Nigerian police, no matter how well trained, no matter how much we perform so well in international engagements, when it comes to our domestic responsibilities and we are found this corrupt, definitely no nation on earth will take us to be a serious nation. And that is why honest businessmen will find it difficult to come to Nigeria for genuine businesses. Many of those who come to Nigeria to trade with us actually believe that anything goes in Nigeria. That is why you have so many Chinese people who are here and they believe that they can ride roughshod over any citizen, because once it gets to the police, they can buy their way through. They will even encourage you to assist them in perverting the laws of the land. And it's so unfortunate that the image of the Nigerian police is so battered, is so terrible, that one cannot even effectively defend such an organization. That is why many young Nigerians took to the streets, because the issue of the EndSARS protests actually were activities not aimed at maybe a particular unit alone. It was a condemnation, a total condemnation of what the Nigerian police as a complete organization is known for today, it will be proper, it will be appropriate that we do a complete overhaul. We do a complete reorientation for the Nigerian police. What we have currently right now is a rogue organization that is not only going into conspiracy with offenders, but is even perpetrating such crimes in grosser dimensions. And it is very, very saddening and disheartening that for a nation that has had records of excellence in the past, that the whole world was looking at as the next superpower coming from the third world, to have found itself in this kind of a situation. No matter how wicked a nation may be. For instance, you know, there are policies of government that may be that may not be democratic, that may be anti-democracy and what have you. But if a nation, because today China may not be regarded as a democratic nation, but once there is good governance to a very large extent, and the police institution is functioning well, you see the international community will take such a nation seriously, unlike a nation that proclaims democracy on the top of its voice and, you know, have it provided in every provision of the laws of the land, only for such a nation to be policed by a rogue organization like the Nigerian Police Force. It is unfortunate. The only thing we can do is to make sure that we look inwards. The government must look inwards, must do a total overhaul, must do a complete reorientation. The kind of, the situation where we have rogue officers going scot-free for offenses that they are known to have committed, to have perpetrated, is not a situation that can engender a free and democratic and progressive society. We need to do something urgently about it.
We certainly do, sir. I'm going to stay on this issue of apparent complicity, but from a different perspective. Abba Kyari is innocent till proved guilty, but there's a burden of proof that's required in a court of law. How is that different from perhaps a burden of proof that's required from one's employer? I'm talking about the fact that Abba Kyari has been suspended but not yet dismissed from the police force. Heaven forbid we suggest that he actually resigns. We know that's unlikely here in Nigeria. But would it amount to unfair dismissal to have him sacked from his position rather than suspended because he has not been convicted by a court of law? Or is the text exchange between himself and Hushpuppi damaging enough to warrant dismissal without being accused of unfairness?
The position of the law in the police, there is what they call ordeal trial or something, which allows the organization itself to take immediate kind of trial, which can be referred to as a special kind of trial to determine whether a person is still competent to be part of the force, because the service they are rendering, just like in the military, we have what we call the court martial, so which will determine the guilt or otherwise of an officer from the professional perspective. In the police, they have such a procedure too. So today they can take a decision to relieve him of his responsibilities. However, for once the offense committed also has civil elements by which it can be prosecuted by the court of law. For his guilt to be determined whether he should go to jail or for any other punishment, such an officer must be arraigned before the court of law that has the jurisdiction to try such an offense. So I would say that it will not amount to double jeopardy if the police institution takes a decision. One, the suspension is to allow probably investigation into the allegation concerning Abba Kyari, which is a recognized procedure in law. However, in determining whether to relieve him, it may have to be removed from the police before he's arraigned before the regular courts. And at the level of the regular courts, if he is now found to be guilty of the offenses, then he may be sentenced to jail for a length of time or for whatever. However, where he is acquitted and discharged, the implication is that the removal in the first place is not correct, is unlawful. he may find his way back into the force, he may be reinstated, and may be entitled to all the benefits, salaries, emoluments, perquisites that he could have lost in the process of the trial and the internal disciplinary measure taken by the police. So in the current situation right now, the decision to suspend him is not far from an approved procedure. However, it cannot continue indefinitely. It cannot be a decision taken without trial. Otherwise, it will amount to punishment without trial. So if he's even sacked from the police as part of the recommendations of the organization itself, as part of the recommendations of the force itself, then immediately he ought to be arraigned before the court. Mere removal without trial in this instance may amount to denial of right to fair hearing in accordance with Section 36 of the Constitution of the Federal Republic of Nigeria. And any decision taken, Abba Kyari may challenge his removal. He may challenge any other punishment meted by the police force if there is no trial convicting him of the particular allegations made against him. So it's on this ground that the organization, the government, needs to be wary and take the appropriate step to ensure that justice is a three-way affair. It should be justice to the victim, whoever was extorted, whoever was the subject of the illegal activity of Abbas, Hushpuppi, and Abba Kyari. The two names they sound somewhat very close. I think it is only a hair that is missing. Maybe that is what brought the relationship in the first place. However, the proper procedure is that it must be a three-way affair: justice to the victim, justice to the accused, and justice to the society. The society in this regard is represented by the government, who is supposed to do the appropriate prosecutorial steps, who is supposed to take the appropriate prosecutorial steps and ensure conviction or acquittal, as the case may be.
Well, thank you, sir. That's the most regrettable relationship that was formed in terms of the damage that it's done to our beleaguered police force, which incidentally is not a rogue organization. We'll get there. Thank you, sir.